My Lords, I think this is the point in the evening where I thank everybody for contributing to a wide-ranging debate, so wide, in fact, that it would probably take me 40 minutes at least to reply. I will try and do the debate justice in shorter time, because the House still has some business. I remind the House that this was dinner hour business, something that the usual channels might look at in future when they do their planning. And of course it was indeed a trailer for the legal aid, sentencing and punishment bill, which is coming to us, known to its friends now as LASPO. And I don't object to colleagues using the opportunity to widen the debate to cover some of those areas. But, you know, Lord Beecham said that it was a tawdry harbinger of a long, hard winter for legal aid. What I would say to the House, to the Bishop, to my noble friend Lord Newton, and to others that it did, the long, hard winter would be if this government didn't face up to the spending cuts that are needed. And it's all very well. Lord Martin said this is a 10% cut is the easy way. I would put it to Lord Martin, the easy way, and we've heard it time and time and time again tonight, is to say, not this cut, not that cut. We do it in a different way. Well, we have had to face up to the fact that we have got to make some hard decisions. And it isn't just this particular part of legal aid that is taking the hit. The Ministry of Justice is a relatively small department with a budget, when we came into office, of 10 billion. We have made a commitment for the spending review to cut that by 2 billion. As the noble Lord Bach knows, we have only 4 major areas: prisons, probation service, legal aid and court services. And all of those have taken their cut. And it is just simply not true to suggest that we have taken a particular easy view on terms of legal aid. And as my noble friend Lord Marx pointed out, and Lord Bach, to be fair, also pointed out, the last Labour government were looking at legal aid, and Lord Bach, the quote from Lord Bach echoed what I went to the Commonwealth Law Officers Conference. I've never used the comparison with continental legal aid because I knew it's a different system. But I particularly sought out the Canadian, the Australian and the New Zealand law officers to talk about legal aid. And they confirmed what Lord Bach knows full well, that they all consider our legal aid system to be, in their terms, absurdly generous. It's also untrue that we have not made comparable cuts in criminal legal aid. In fact, the parallel order will, over the period, save some 80 million in criminal legal aid spending. He particularly mentioned the case of Law for All. It's an interesting thing because it very much echoes the same kind of thing that was said when the Immigration Advisory Service closed. And let's be fair, this is closed before any of these legal aid cuts have come in. So it isn't that it's the legal aid cuts that's called the collapse. But what is interesting is that the Legal Service Commission was able to make provisions from other providers, and I'll return to that in a few minutes. Also the fact that, yes, we have recognised the problem about CABs and law centres, and I will try in my main remarks to cover that. Baroness Deach made an interesting point. Now, I'm very proud to be so, the Minister responsible for promoting diversity in the legal profession. And I would put it to her that it is not a matter for diversity to suggest that women and black and ethnic minority lawyers should be corralled in one part of the legal profession. Indeed, my drive in terms of diversity, and she's quite right, and I've talked both to the Bar Council and Law Society about this, is that there is a responsibility on the profession as a whole to promote diversity. Not diversity in the narrow area of legal aid, but across the profession. And to be fair, I do think that they are responding to pressure in that area. And we are taking the question of diversity extremely seriously. She also, and a number mentioned the Family Justice Review. It is a separate and independent programme of work looking at the entire family justice system. Our proposals are not dependent on the outcome of that review and are focused on legal aid. These proposals go in the same direction as and in support of the aims of the Family Justice Review, which I'm assured will be published very shortly. Baroness Dietz and a number of others talked about the fee levels will reduce access to good quality experts. The benchmark rates for experts have been applied by the Legal Service Commission for some time, and the truth is there's only limited anecdotal reports of problems about access to experts. Lord Scott accused us of weasel words in the explanatory memorandum. Well, I hope my opening has removed the weasel words. Of course, much of this has been driven by the need for cuts in public expenditure, but we have tried to do so in a way that focuses the legal aid on the most needy. And, you know, we go back to the issue of a level of spending. What is so sacrosanct about 2.2 billion? It certainly wasn't sacrosanct for the last Labour government because they were planning to cut it anyway. And it is not a system where it is being dismantled. I mean, this doesn't help when Lord Beecham makes that kind of sum. It simply does not. I could make some quotes about the earnings of barristers in family legal aid work, but let's not go down there. Let me turn instead to the points made by Lord Listowel and the Bishop of Ripon and Leeds. I think there is a point about the idea about whether the Legal Services Commission should be able to commission experts direct, and I think that's something that could well be looked at. On the matter of the aid to children, we will retain legal aid for child parties in family cases. In 2009-10, we provided 133 million of civil legal aid funding to child parties in all categories of law, and under our proposals, around 95% of that aid would continue. I hope that gives some reassurance to the points that the Noble Lord was raising. Apart from getting some of the previous government's record on the into Hansard, I'm also grateful to Lord Bach for the point out that we are consciously, and the Lord Chancellor has pointed to this, consciously looking for an approach to the settlement of disputes which is less legalistic, which brings in mediation and alternative dispute resolution, and also that we were looking and possibly legislating in the next session of Parliament on court efficiencies. Lord Beecham talked about supply side likely to diminish, and I will try and cover that in a moment. But it's certainly not right to say that we didn't consult widely. The reforms were subject to full public consultation, which ran from the 15th of November 2010 to the 14th of February 2011 and elicited over 5,000 responses. Lord Newton said...
I'm grateful to the Noble Lord. The point was in relation to the fees order, not the Green Paper. The lack of consultation to which I referred and quoted the young legal aid lawyers was in relation to this order, not the Green Paper.
These were all foreshadowed in the Green Paper. On Lord Newton, well, he's not a happy bunny, but I've got to say again, as I said to Lord Beecham, if we were not willing to take tough decisions, there'd be a lot more unhappy bunnies around, because we'd be paying interest rates 2, 3, 4 times what we're paying now, and would result in cuts in public expenditure and in services far, far greater than that. And the fact that our government is not making headlines for the economic situation it finds itself in is because we had the courage to take the tough decisions early. And I have no doubt that when we ask colleagues to take, and the opposition to face up to that fact, we will always have the problem that these are, and we've never resiled from this, tough decisions. But on the specific... yeah, but we are very late, you know.
Yes, I realise that. But he's just made a rather extraordinary statement. He said that we'd be paying interest rates 3, 4 or times greater than we are now. I just don't understand what he means.
What are the rates that Ireland are borrowing at the moment? What are the rates that Ireland are borrowing at the moment? What I'm suggesting is that if we'd have lost control of our economy in the way that some parts of Europe have lost control of our economy, the consequences for public expenditure would have been very, very much more severe. And I would have thought I'd have had the support of my right honourable noble friend in that.
No one is more enthusiastic than I am that we should cut the deficit as fast as possible. And I've made that clear time and time again. I just did not understand the quantitative statement which you made, but I wouldn't wish to delay the House further.
Thank you, my Lord. On the points that Lord Newton made, legal aid is currently available for legal advice on any mental health matter and representation for mental health matters heard in the county court, such as charging a detained person's nearest relative for mental health legislation purposes, for damages claims and for representation before the first-tier mental health tribunal and onward proposed. We propose retaining these cases within the scope of legal aid. In 2010, tenders for legal aid contracts for mental health demonstrated a strong demand for mental health work, with nearly 3 times as many new cases bids than there were cases available. I think that covers I hope that answers the points that Lord Newton was raising. Namely that there is the supply that he was concerned about, and that we will continue this in scope. My Lords, the House will be aware, as I've said, that the government has had to make some tough decisions, and as I mentioned, Lord Bach accepted when he had responsibilities for this matter that the Legal Aid Fund must play a part in the often difficult exercise. But to govern is to choose. It is a key role of government on behalf of the taxpayer to ensure that the amount it pays for any service represents maximum value for money. In this context, it is essential that the government ensure that it only pays the rates that are necessary to secure the level of services that are required. While this may not be welcomed by those who provide services funded by legal aid, and it is a reality that suppliers of other services across the country face this reality on a daily basis. The government recognises that some providers may choose not to continue to provide legally aided services in this environment, but it is not the purpose of the legal aid system to sustain the current legal market. Rather, we want to continue to have a sufficient supply of providers of satisfactory quality to provide an appropriate level of services to legally aided clients. The order which we are debating this evening introduces a number of changes to the fees that the provider can currently receive for carrying out legal aid work, and the main features were referred to by Lord Bach. Justice is required to make savings in the year 2014-15 of about 50 million. My noble friend Lord Marx referred to the total savings of 120 million. With the exception of the family fee reforms, which will take effect on February 1st, 2012, when new contracts under the family retender exercise are expected to commence, the new fees took effect on 3rd of October 2011 and apply to all cases commenced after that date. The reforms were subject to a full public consultation, which ran from the 15th of November 2010 to 14th of February 2011. I've already referred that in reply to Lord Beecham. With the exception of the Law Society, no respondents provided any form of detailed numerical analysis on the market. The Law Society did through Mr. Andrew Otterburn. His report indicated that while the fee reduction will inevitably reduce the income of solicitor firms, on the whole they would still make a profit even before making any efficiencies in working practices. Subsequent to his report, Mr. Otterburn specifically confirmed to the MOJ that in his view an overall phased reduction in fees of around 10%, with the reduced fees only applying to new cases commenced after the implementation date, would allow solicitor firms time to adjust to the new fee levels and would not therefore necessarily make supply unsustainable. The government accepts that the proposed reforms may be particularly challenging to the not-for-profit sector, and that was raised by a number of colleagues. However, it is also the case that the major issue for this sector generally are changes to other sources of funding, for example, as was acknowledged by Lord Bach, and local authority cuts, which may make the supply in the areas they cover vulnerable in any event. This is clearly a matter of concern for the government as a whole, and the issue of the future of the voluntary sector will be considered as a part of a cross-government review on which an expected announcement will be made shortly. In the interim, the government has already provided transition funding to assist not-for-profit sector to adapt to changing financial environments, and I understand that overall 45 individual CABs and 17 law centres have taken advantage of this fund. As the noble Lord will be aware, the government will also be providing a further 20 million of funding for the not-profit sector, and specific details of this fund will be made available shortly. In the context of legal aid services, the issue is whether services will be available for clients rather than whether the service is provided by any particular provider. We assess that the likely impact of the reforms, when considering the responses to the consultation and overall, are satisfied that the reforms are sustainable, and that although individual providers may leave the legal aid scheme, there will be a sufficient supply of providers of satisfactory quality to provide an appropriate level of services in the law. The government therefore considers that the fee reductions will be sustainable and ensure that clients can continue access to legally aided services. As the noble lords will be aware, the Justice Committee report on legal aid concluded that given the extent of savings which the Ministry of Justice is having to make, in principle it is correct that fees should be reduced. We are willing to look at areas of isolation, the problems of the so-called legal aid deserts, and there are a number of actions that the legal service Commission can take to mitigate shortfalls if they develop. It's also true, as I also referred to earlier, that some of the fears of that people would not come forward have not borne out in areas where individual firms have collapsed. Indeed, in all the areas where we are putting forward contracts, there has been an oversupply in terms of those seeking that work. And also, my Lords, there is a genuine alternative the Community Legal Advice telephone helpline is an alternative for those involved in legal aid. I see Lord Beecham shaking his head. I was interested the other night. I went to a Law Society function giving prizes to successful law terms, and I was amazed how many of the prize winners were offering online and distance advice in terms. So, you know, the old idea of face-to-face may not survive. But there's no doubt in my mind that the legal profession is a profession in transition in many, many respects. I'm being told to shut up, and I will do. But the fact is that, as I said, wherever we have been looking at new contracts, we have found that they've been oversubscribed. So I don't think that this is the issue that is suggested. And it isn't a 10% cut per individual. It is a challenge to those firms and the legal profession indeed to find different methods of service, different structures, different efficiencies, a pattern that many professions and many industries have found over the years. But we are confident there are sufficient numbers of providers willing to remain in the legal aid market. I'm well aware that a lot of what we've discussed today is, as I say, a dress rehearsal for when the LASPO bill comes. But I do not believe that it would be right to pass this prayer this evening, and I sincerely hope that Lord Bach will resist putting it to a vote.
Well, my Lords, can I thank all noble lords who've taken part in this debate, including, of course, and especially the Minister for his wind-up. Can I give the House the good news, which is that I certainly don't intend to divide the House. I'd very much like to, particularly with the degree of support for my motion tonight around the House, and I'm most grateful to noble lords who've supported me, as I say, from around the House. But actually it's too late to call a vote tonight, and actually I'm not certain that it would be the right thing to do in any event, given that the bill is due to come to this House next month. So I won't be calling a vote, so anyone who wants to go now, please feel free. I'm afraid, though, it wasn't the Minister's arguments that persuaded me not to call the vote. Indeed, if it had gone on much longer, I might have been tempted to in any event. No, with great respect, let me make a few points, if I can, and then the House can move on. The very, very good speeches made, if I may say so, by the noble Baroness Lady Deach, talking about the bar with a great experience and knowledge. The noble and learned Lord Scott of Foscott made some very important points, one of which I'm going to come back to at the end of what I've got to say. The Earl of Listowel and the Right Reverend the Bishop of Ripon and Leeds, both with their concern for children law, if I can call it that, were right on the spot, I thought. My noble friend, as always, Lord Beecham, with his experience, made very telling points. And certainly not last but certainly not least, the noble Lord Newton of Braintree made a very telling contribution, and one I think that the government side should listen to with some concern. As to Lord Marx's speech, of course, I admired his loyalty, perhaps rather more his loyalty to the government and to the noble Lord the Minister than perhaps to his party, which, as I understand it, has twice this year already made it clear at conferences that they don't like the way in which the government is behaving towards legal aid. He asked me to state which cuts we'd have made in government. I'm not sure he was listening with his usual care to what I said in my opening remarks, which was that we put out a white paper, the last Lord Chancellor and myself, called Restructuring the Criminal Defence Services, which, if we'd been elected, which we weren't, we would almost certainly have, I'd have thought, put into effect, which would have saved a great deal of money. It would have been controversial. I've no doubt there would have been debates in this House too. And I did notice that in his interesting speech there was nothing at all about social welfare law, whether he thought it was right to attack social welfare law or not. After all, what I had to say early on was very much based around that particular part of this order, and very little said by him about criminal law either, about whether savings might be made in that field. Now, he quoted figures, of course, speeches I'd made, in which I think legal aid ministers down the years, and no doubt in the future, about how generous our legal aid system is compared to the ghastly rest of the world. Let me tell him, yes, I did use those phrases, of course, and there is some justification in them, but not perhaps quite as much as I used to think when I spouted those words, to be honest. New Zealand, for example. We compare ourselves with New Zealand and say, my gosh, New Zealand, another common law country, just gives a much less amount for legal aid than we do. It's a quite different situation in New Zealand. There, for example, there's no liability compensation, which of course costs a great deal in this country, and there are other considerations as well. So let me be absolutely frank. When we were in government in this field, I've no doubt we made mistakes. I'm sure we did. There's no doubt in my mind that his government is making mistakes now as well. And actually we're dealing, and perhaps the noble Lord Marx will remember this next time he speaks to the House on these matters, we're dealing with what his government are intending to do, not what my government did or didn't do when it was in office. My Lords, let me just say this. The Law Society have suggested savings of up to £350 million as an alternative to the legal aid cuts that the government are putting forward. We look forward very much to hearing, we didn't hear tonight, what's wrong with the Law Society's
What's wrong with the Law Society's figures is it doesn't save public expenditure to shuffle the costs around Whitehall to other departments or to propose extra taxation on alcohol. That isn't saving public expenditure, that's shuffling the pack.
Well, perhaps the noble Lord, if he's right, will explain to me how then decimating social welfare law with its few savings to the Ministry of Justice, how he explains that that is going to cost infinitely more to the state as a whole when problems aren't solved, when people are chucked out of their houses, when debts grow bigger, when families break down, when children commit crime. Other departments will have to pick up the pieces for the paltry savings the Ministry of Justice will make. So please don't give us that stuff about public spending. The truth is, these are Ministry of Justice savings, which I accept they have to find a number of savings. We've said that. But the Ministry of Justice savings that will actually cost the state and the community much, much more. Because as the noble and learned Lord Scott of Foskett said, civil legal aid is not an optional extra. The concern is that this government is treating it just as an optional extra. And the cost will be much, much greater. We could see which way the government was going as far as legal aid was concerned way back in June or July 2010, when out of the blue they removed the grant that the grants that were given by the Legal Services Commission for young legal aid lawyers to get legal contracts with legal aid firms. Few million a year, if that. But they abolished that at the start, and we should have been wise then to what they are planning to do now. There was absolutely no reason for doing that, and there can't be any reason for doing what they are now tend to do to social welfare law. Legal aid in the civil field is well worth protecting. And I end, if I may, with a quote from Supreme Court Justice Lewis F. Powell, who said about the American system, but it could just as easily be applied to the British system. Equal justice under law is not merely a caption on the facade of the Supreme Court building. It is perhaps the most inspiring ideal of our society. It is one of the ends for which our entire legal system exists. It is fundamental that justice should be the same in substance and availability without regard to economic status. He was right. I only hope that the government changes its mind. I beg to withdraw the motion.
Your Lordship's pleasure, the motion be withdrawn. Motion is by leave withdrawn.